Okay, looks like we've got everybody who's trying to log in logged in. So I'd like to welcome everybody to Making the OMA Simpler. My name is Anthony J. Scerbo, and I'm an attorney advisor with the Office of Open Government. I am joined today by the Director of Open Government, Nicole Allen, my colleagues, attorneys Brandon Lewis and Joan Lelma, who will be minding the chat and will either be answering questions or directing them to me while I'm doing the presentation. I'd like to welcome everybody, regardless of which agency, board, commission you are from. We're always glad to have folks ready to learn about the Open Meetings Act, and particularly my emphasis today, as I'm going to say, is I'm going to address some of the common problems that we know people have faced, try to make answering those issues simple. Ms. Candelaria, if you could mute, that would be great. Thank you. All right, so I'm going to share my screen. I'm going to PowerPoint. All right, let's slideshow. All right, so here we are. As I say, we're going to make the OMA simpler today, or we're at least going to try. We will start out with some of the fundamentals. You know, the preamble in the DC Code states that the public policy of our district is that all persons are entitled to full and complete information. And that means that business, the public's business conducted in meetings, is part of our code. The OMA is defined as it shall be construed broadly to maximize public access to meetings. An exception shall be construed narrowly and shall permit closure of meetings only as authorized by this act. Cannot stress this enough in these troubled times, that this is a matter of great importance. Currently, as many of you may know, there is an emergency bit of legislation passed by the council that amended the OMA. This emergency legislation will be in effect until July 6th of this year. I'm not going to belabor the changes. Where they're of note to public bodies generally, I will, briefly note them in the presentation. For the most part, the substantive changes or the major changes in the act under the emergency legislation apply to the council and the council alone. So as I say, I'm not going to belabor that, but I will try to make the points where they occur. So let's talk about who is subject. Under the OMA, public bodies are subject, and that is defined as any government council, including the council, a board, a commission, or a similar entity. And we've had entities that are not called those things, but are called something else, but nevertheless, by their very nature, are subject. That includes advisory bodies that take official action by the vote of their members that are there for that purpose. Now, that does encompass a wide group of public bodies. However, there are certain specifically excluded groups, such as the DC courts and area neighborhood commissions. These are the enumerated bodies from the statute itself: local school advisory teams, the council. Now, as I note here, the legislation that changes matters relating to the council does expire on July 6th. Boards and commissions, boards of directors. This could also include, and in most cases does include, boards of trustees. That would be advisory boards, and then the public charter school boards, boards of trustees as well. This is a general overview. District agencies that may support the type of public bodies that are covered by the OMA, but the agencies themselves, the mayor's cabinet, ANCs, the courts, and the professional staff that supports the public bodies are not per se covered by the OMA unless otherwise stated in legislation. So the Open Meetings Act is centered upon meetings. And the question is, what is a meeting? And a meeting is is defined by two key things: its purpose, which is to perform the public's business, and the presence of a quorum. And under the law, all such meetings, unless specifically and legally exempted, are presumed. So there is a rebuttable presumption to be open to the public, and the public has to receive advance notice of date, time, place, and draft agenda. And we will cover all of those individually. This is the legislative definition of a meeting under the OMA. Gathering a quorum of a public body, whether formal or informal, regular, special, or emergency, at which the members consider, conduct, or advise on public business, including gathering information, taking testimony, discussing, deliberating, recommending, and the statute says and voting, but that is interpreted to mean and or voting, regardless of whether held in person, by telephone, electronically, or by other means of communication. And I'm going to discuss the parts of this that need to be considered and the parts that don't, because, for example, it doesn't matter whether meeting's formal or informal. If it's the public business, it would be. So that would not be relevant, because either way, it would be a meeting as defined by the OMA. So the relevant meetings: is it a public body? Is there a gathering of a quorum? Are the members present as a quorum, not staff, not members of the public or the media, but the members themselves? Are they conducting public business? And that would include considering, conducting, or advising. And within that, you can work through this list. Is there gathering of information? Is testimony being taken? Is there a discussion, a deliberation? Are recommendations being made? And is there voting for official purposes going on? That would make it an OMA meeting, establishing those criteria. What's not relevant is formal or informal. So either would apply. Regular, special, or emergency. Those are the three types of meetings that are defined by the statute. Any type, it's still a meeting. And in person, by phone, electronically, or by other means, again, by any means. So the method, the platform in which the meeting is occurring is not relevant. It would still be an open meeting if this criteria here was in place. Now, we've talked about what a meeting is. Let's talk about what a meeting is not. It's not a chance or social gathering where no public business is discussed. Now, I need to make a clarification here. Where no public business is discussed, but also within the statute, you cannot arrange a social gathering or meeting and attempt to disguise it in an attempt to evade the Open Meetings Act. That is specifically prohibited by the statute. We get this question perhaps as much, if not more than any other, when it comes to conduct of meetings. A committee or subcommittee meeting is not a meeting according to the OMA, subject to the OMA, if there is less than a quorum of the entire body present. So if the entire body is 10 members, then quorum of that body is 6 members, unless a statute or a mayor's order or enabling legislation says otherwise. Then that quorum would be 6. So if you're having a committee or subcommittee meeting with less than 6 members of the full body, that meeting of that committee or subcommittee is not subject to the OMA. Again, however, you cannot deliberately arrange meetings so that they're conducted what is called serially, in order, where there's multiple meetings of members below that number, but nevertheless, you're trying to evade the requirements of the Open Meetings Act. Press conferences are not meetings according to the Open Meetings Act, by their inherent nature. The press is present. And email exchanges, again, are not per se meetings according to the Open Meetings Act. However, courts have held that attempts to evade the Open Meetings Act by the use of exchanges via email that are nearly or are simultaneous may be violations of Open Meetings Act. And we would consider the same in the district if it was clear that there was a pattern or practice of attempting to evade the Open Meetings Act by using email exchange. Single one-way or brief exchange of information, not an OMA meeting. Extended communication on public business. There's that list again of the things that you can use to guide you. May be interpreted as an attempt to evade the OMA, and it's not allowed. The key issue is how simultaneous. If days pass between exchanges of information or messages, that would clearly not be a violation. If, on the other hand, there were very short periods of time and it was back and forth among a quorum of members, that quite possibly would be interpreted that way. Again, we get this question, so I'm going to just show the normal rule. If there's not legislation, a mayor's order, a bylaw, etc., to say otherwise, the normal rule for quorum is divide the full body membership by 2 and add 1. It doesn't have to be any more complicated than that. But for some reason, it gets folks spun around the axle. The OMA currently allows public bodies to meet via electronic methods, video conference, phone conference, or other electronic means if the following are true. Reasonable arrangements are made to accommodate the public's right to attend. The meetings are, and there's subordinate portions, and that, by that I mean open and closed sessions are also recorded. All votes are recorded. Now I have that highlighted in red because that currently is a change. The permanent version of the Open Meetings Act says that it has to be by roll call vote. Currently, the change in the legislation is that all votes are recorded. And then all the other provisions of the OMA have to be adhered to. We use the word open. What does that mean? It means the public is allowed to be physically present if the members are physically meeting, that the media is physically present if the members are meeting physically, and that if they're meeting by a form of internet, TV, radio, etc., then the public has access via those means. For the council, for example, they not only broadcast on the internet, but they also broadcast via the DC local access cable channel. Every OMA subject meeting has to be noticed. And again, you're going to see this red underlined text because this is a change under the current emergency legislation. Currently, a public body shall attempt to provide notice as early as possible, but must be given 48 hours or 2 business days before the meeting, whichever is greater. Notice has to be physically posted in the office or a place readily accessible to the public. If you are in a multi-story building and there is a bulletin board in the lobby of your building, and the public does not have access to the upper floors outside your office, then yes, you can post that notice physically in the bulletin board, because that is a place where the public could, in fact, see this notice posted. This is another thing that we get a lot of questions about and people get wrapped around the axle about. The Office of Open Government under the Board of Ethics and Government Accountability, or BEGA, offer what is called the Central Meeting Calendar, again at open-dc.gov, which is where if you want the training materials and a link to the recording, you will go later, for the convenience of both the public and the public body. Notice has to be posted either on the public body's website and or the central meeting calendar at open-dc. I will ask what I always ask, and my colleagues, get tired of hearing me say, I will ask anyone who is the administrative point of contact or chair of the public, please post in both locations. Please just exceed the minimum requirements of the act. Some people will look to the central meeting calendar, others will look to the website. It's just easier to create greater transparency and openness if notice of meetings is posted at both locations. And then additionally, notwithstanding the other requirements, the public body has to notice meetings as timely as practicable, and that's very greasy legislative language, in the DC Register, except for the meetings of the boards of trustees for public charter schools. What this means is if you have an additional special, what's called a special meeting, which is an extra meeting or an actual emergency meeting, you may not have time to get into the issue of the register that precedes the meeting you're going to have. As timely as practicable just means that you still have to provide the public notice, even if it goes in and doesn't appear in the published version of the register online until after the meeting's occurred. Now, certainly for regular meetings, which are meetings that are scheduled in advance and are normally part of your annual calendar of meetings, this should not be a problem. But as timely as practical means that if, in fact, you had a meeting that came up and there wasn't sufficient time, it's all right to have your notice appear in the register, even if it appears after the meeting occurred. I've talked about the need to notice meetings, the requirements of notice. Let's talk about what notice includes. Notice has to include the following data: time, date, location, if it's a physical location and or if it's online, and if it is online, hyperlink and or joining information depending on the platform, WebEx, Zoom, Teams, etc., that's being used, and the planned or draft agenda. Now, if you anticipate or have reason to know that there will be a closed portion of the meeting, notice also has to include the OMA citation, which we'll talk about, with the reasons justifying the closed portion of the meeting. We're going to talk about that here momentarily. Also, on the notice, which you can think of as an actual thing, the notice can be a document. It doesn't have to be. You can list the information on the websites, either website, and then just attach an agenda. But it's just so much easier if you just simply take the agenda that you plan to have and have the time, date, location, links if necessary, and then you have to include the following statement in all draft and final agendas. This meeting is governed by the Open Meetings Act. Please address any questions or complaints arising under this meeting to the Office of Open Government at open.govoffice@dc.gov. And that is a DC regulation located at 3 DCMR, section 10409.2. Very easy to look up if you so choose. As I mentioned, notice in the office or location credible on the website. For open meetings or emergency meetings, as I said, I wanted to bring this up. If there's an emergency meeting, that means a meeting that there's some reason why a meeting has to be held immediately. It's not an extra meeting. It's not a regular meeting. Then the public body can either use the regular internet posting method, or they can post a physical paper notice in the office, or a location readily accessible, like I said, in a lobby or on a bulletin board. And you also still must publish in the DC Register as timely as practicable. So if it's an emergency meeting, obviously it's almost certainly going to appear in the register after the meeting has occurred. Now, I've developed this graphic. It will either be as clear as crystal or clear as mud. I want to thank my colleague, our paralegal specialist, Kim Brown, for helping me. I'm hoping this will help. So notice, here's our central document. This is total notice. It includes the day, the time, the location and or the web link. It has the agenda. The agenda has the governance language that I just showed you about the Open Meetings Act governing the meeting. And if necessary, if there's going to be closure of a portion of the meeting, there's reference to that. And then this notice that includes this information is posted at the office or in a location accessible to the public. It's posted on Open-DC and or the body's website, and it is posted to the DC Register. Now, for quick reference, I'm going to do this one more time. Notice includes time, date, address, and or links with the draft agenda, including the OMA statement, whether the meeting is expected to have a closed portion, including the citations to the OMA, and then it needs to be posted in or around the office, on the CMC and or on the website, and published in the register. I don't know whether that helps. As I say, it'll be available in the slides, but it's a quick reference just to make sure that you've got all your I's dotted and your T's crossed. And again, please remember, this is that statement again that needs to be in all agendas. If you just create an agenda template and include this language and leave it in there, you'll never end up with any difficulties as far as the governance language. Talked about closed sessions, and the notice should include, if feasible, the description of matters to be discussed under 2-57B. 2-575B is part of the OMA that gives the various justifications that are allowed to allow a body to go into a closed session. And 2-5765 is where the requirement for a description. It's a general description. It does not go into specifics. It doesn't ask you to discuss confidential or proprietary information, just a general description of the matters to be discussed in closure. But the closure in a meeting has to include the citation, the justification, and a description. This isn't a comprehensive list. For the full list, here's the link to the section of the code for 575B. But some general justifications are: a court order or statute requires it, there are contract negotiations involved, discussion of trade secrets which need to be protected, the need for protecting the attorney-client privilege. Now, that doesn't mean that there's just an attorney present. That means that there's actually consultation with the attorney for the public body, or an attorney for the public body, where the privilege would be invoked. We've seen this with the pandemic, public health or safety. If disclosure could endanger the public, maybe there's a discussion of steps that need to be taken to prepare for a growing public health emergency. To prevent the premature disclosure of an award. Obviously people want to surprise someone with an achievement, provide them an award, and they want to make sure that that isn't disclosed prematurely. And then, certain other administrative information, examination questions, personnel information, students' personally identifiable information, etc. And as I say, the full list is available at the link provided above. So how do you go into a closed session? Again, this is on our top 10 list of things that we get asked the most. You go into open session, you establish your quorum, and if you choose, you conduct the business for the open session. You can also conduct the business for the open session following your closed session. But say you are ready at whatever point to move into closed session. So someone would make a motion among the body to enter into closed session. A vote would be taken. The chair would reference the OMA citation under 2-575B that justified the closure. It would give the brief explanation or description of what was going to be covered in closure. The vote would be taken, and assuming the motion passes, the body could then enter into closed session. Now, that could be done physically by removing itself to a different physical room. It could be done virtually by going from, say, WebEx, where we are now, into a Zoom or another WebEx and conducting a separate closed session. That session, and I'm about to show, you only discuss the matters discussed on the agenda, referenced on the agenda, and that are covered by the exemption under 575B. You record the executive or closed session separately. You don't have to record it separately, but if the public asks for your open session recording and your closed session recording is a portion of it, you obviously will have to perform some form of editing or redaction. And the best practice that we recommend is simply to record your open session from beginning to end, even if there's a gap for a closed session occurring elsewhere, and then record the closed session. When you're done with your closed session business, you would reopen the public session, and where appropriate, you would report publicly any official action taken in closure and either go on with your open session business or adjourn. It's really a three-step process. You start out in open, At some point you go into closed, at some point you come out of closed, and then adjourn. Now, I've mentioned recording. Let's be clear. All meetings have to be recorded, open and closed sessions. And the law only allows for when a recording is not feasible, detailed meeting minutes shall be taken. Now, there's two things here. I always advise that meeting minutes be taken regardless. Technology fails, people forget things, what have you. Detailed meeting minutes do not have to be the great American novel. They simply need to say the date, the time, the location, the members present, the members absent, any considerations, a brief description of discussions. That's it. I've seen very good detailed meeting minutes that were not much more than a page. I've seen not such great detailed meeting minutes that were 4 or 5 pages long for a 1-hour meeting. But the recording not being feasible, that is only in an extreme situation or contingency. That's not because nobody's bothered to get the equipment, nobody's bothered to arrange to learn how to record from a platform, etc. Those are expected and required. And so if a body does not know how to arrange for recording, a cell phone video can suffice as long as it can be provided upon request to the public. And speaking of the public, copies of records, and that would include recordings, shall be made available for public inspection. So the minutes, if minutes are taken, are as soon as practicable, but no later than 3 business days after a meeting, except for the public charter schools. And the full record, which would include recordings, video, audio, etc., internet, are as soon as practicable, but no later than 7 business days after the meeting. Sometimes a meeting isn't over 5 minutes and our office will get a request for, I'd like to request a recording. Well, first of all, we don't post the recordings of other bodies' meetings other than the Board of Ethics and Government Accountability. And 2, that doesn't take into account that the public body does have, the 3 and 7 business days to make them available. This is just another quick version reiteration. Draft detailed meeting minutes, 3 business days. If they're going to be draft meeting minutes, and they should be until the body votes to make them official or final, then a notation should be included at the top of the document that those detailed or final meeting minutes will be posted to the body's website or the central meeting calendar on the next meeting date. That's normally when a body will vote to approve the minutes of a prior meeting. Audio recordings, video recordings, transcripts, which is another copy of the full record, have to be available no later than 7 business days. As I said, detailed meeting minutes have to contain date, time, place, names of members present or absent, motions and amendments, a record of all votes taken, and a general description. And this is the reference to the regulation that makes this so. This is another just quick reference, something to keep on your bulletin board or your wall if you so choose. Please note, we've had this issue in the past. If you choose to post your agendas, your minutes, your final minutes, etc., on the central meeting calendar, please understand it's provided for convenience for the body and for the public and for greater awareness. However, we are not responsible if that is the place you choose to put your only copy of something. We're not a storage or record retention function with the central meeting calendar. So you still are required to preserve, according to all the record retention laws and regulations in the district, your own records. Another of our top 5 issues that we hear from people or from the public comment. Your legislation, a mayor's order, your bylaws may require a public comment function or a public comment period. That is entirely up to the rule or the law that governs that. However, the OMA does not have a public comment requirement, and neither do its regulations. So if you allow public comments, or if it is subject to the internal or external law or rules, so be it. And you can even have a standing order permitting it. And you should follow, as a best practice, consistent rules for equal protection. And this is a constitutional question if you choose to do so. But this is not something that the Open Meetings Act governs, and this is not something that we enforce. So all of the things being equal, you've got a regular or special or even an emergency meeting scheduled, and something happens. A meeting can be canceled just like a meeting can be scheduled. A cancellation is a change in schedule, just as the scheduling of a meeting is change in schedule. In most cases, except for emergencies, cancellation requires as much notice to the public as possible, but not less than 48 hours or 2 business days before the meeting. This is just like noticing the meeting itself. And again, it's not difficult if you've already got a notice posted to establish for the record. The meeting notice, the public just would say canceled. You go on the central meeting calendar, you put the word canceled ahead of the title of the meeting. You put it on the agenda. You do the same on your website. It's very easy, and that satisfies the requirements regarding cancellation. As I mentioned, Director Allen is with us today. The Director of Open Government, according to the regulations, may provide advice and training on parliamentary procedure upon request. And we've had a big uptick in the last couple of years in requests. So the Director established a DC training portal in conjunction with Robert's Rules Made Simple. And I'm going to share the QR code, which you're more than welcome to take a screenshot of with your phone, link yourself. The website link is also here. You can go to robertsrulesmadesimple.com/DC, and you can register for free for training regarding small body parliamentary procedure, how to run meetings more effectively, the Open Meetings Act, etc. It's a great resource, and it is available for free to members of the support staff and the public bodies. So again, I'm going to leave this up for just a moment in case anybody does want to capture the QR code, but you can also capture it from the video or slides when they get posted. In addition, it's a good practice, it's a best practice for either the administrative point of contact or the presiding officer themselves to write a script for meetings so that they can move smoothly through and ensure compliance with the requirements of the OMA. It's not hard. And if there's difficulty in drafting a parliamentary procedure script, myself and my colleagues are available to assist in helping you develop a script template for meetings. It doesn't take especially long. And as I say, we're available to help if needed. I mentioned a couple of times administrative points of contact. We need an administrative point of contact with each public body. They're the legally responsive person to whom we address issues or concerns or complaints on OMA violations or compliance. And we do ask that whenever the duties of the administrative point of contact change hands, someone leaves, someone new begins, positions change, please provide us the new name and contact information, and we will make sure to get that person, i.e. the new person, set up with credentials so that they can use the central meeting calendar at open-dc.gov and provide instructions on how to do so. As I mentioned, to post notices of minutes and transcripts, the APC contacts us to get the login credentials. We're an alternative and a supplement. But you can use your own website to post the required materials as well. These are reference sources. Our website is open-dc.gov. We've provided online a compliance checklist for the OMA. Now that's for the permanent version. There's only a few minor discrepancies under the emergency legislation, but again, consult us if you have a question. The DC official code listing under the legislative information management system and under the code that is listed there is available at the council website under code.dccouncil.gov. And then the regs, which I've mentioned several times, are available. All the rules, the regs, excuse me, that apply to the OMA are at this link. This is our contact information, including mine, as well as the directors, our chief counsel, Louis Neal, as I say, my two colleagues, our paralegal specialist, and our IT specialist, Kevin Brown. If you have general issues with the website, you can reach out to the open.gov office email, but you can also email our IT specialist directly or copy both, which is probably the best practice. And with that, I'm going to thank you and thank you all for everything that you do. And I'm going to stop sharing my screen and see if there are any questions that I or we can answer. Okay, so yes.
Oh, I was just going to say I have a question.
Yes.
So when it comes to making sure that the public is aware of all of the information for these meetings, is it sufficient to let the public know that if they would like to attend, they can reach out for that information, or does that need to be readily available just as is?
The public needs, that's a proactive requirement. So instead of saying, you know, we're having a meeting, if you want to attend, reach out to us. That's a form almost of pre-registration, and that is not what the OMA countenance is. So you do need to provide that information proactively up front.
Okay, thank you. Just checking.
Certainly. Do we have any other questions?
Lisa Slover had a hand up.
And that was Lisa, I believe, that just asked your question.
Lisa. Okay, sorry.
No problem. Okay, I'm going to do the normal auctioneer bit, going, gone. Again, the material will be posted on Open-DC later today. If you have any other questions, you can reach out to myself or the OpenGov office, and I or one of my colleagues will happily get back to you. On behalf of the director, chief counsel, and the rest of our staff, I want to thank you for attending today. It's great to see everybody, and I hope you all have a dry, sunny day.